You've won, you've won, you've won. So blame it on my...
Can you talk now, please?
Check, mic check 1, 2.
Okay, I got it now. I don't know what was going on, but I got it now. Okay, so sorry for that, but I think we got it sorted out, and I did. So sorry for that.
Competition, without regard to team assignment, advanced to tonight's final round. Tonight, we will watch the 4 finalists compete for the following prizes: Best Oralist and Best Team. Additionally, we will announce the winner of Best Brief and also present the Carolyn Forrest Moot Court Competition Recognition of Achievement. We are pleased to announce that the 4 finalists here today will be offered the opportunity of summer employment opportunities with a top law firm, media company, or First Amendment nonprofit, thanks to the generous support of the ABA Forum organizing sponsors. I'm being told that we are still unable to be heard by the public.
Les, you're good. You're good, Esther.
Okay, so we'll continue on. Sorry about that. We are honored to have 3 esteemed jurors presiding for today's competition. Judge James Ho of the United States Court of Appeals for the Fifth Circuit, Judge Kim McLean Wardlaw of the United States Court of Appeals for the Ninth Circuit, and Judge James E. Graves of the United States Court of Appeals for the Fifth Circuit. Judge Graves will serve as the Chief Justice for tonight's competition. We are also honored to introduce our finalists: Emery Powers, Tiffany King, Logan Kirkpatrick, and Apratim Vidyarthi. Now I would like to introduce Summer Dean, who will serve as our timekeeper for this evening's competition.
Thank you, Esther. Good evening, everyone. The United States Court of Appeals for the 12th Circuit is now in session. Judges Ho, Wardrow, and Chief Judge Graves presiding. Now before the court is case number 20 CV 921, appellant Justin Figg versus appellee Karen Newton on appeal from the decision of the United States District Court for the District of Portlandia. Each team is allotted 20 minutes to present its arguments, and counsel for the appellant may reserve up to 5 minutes of their allotted time for rebuttal by seeking leave of the panel to do so. The judges will indicate when they are ready for you to begin.
Is the appellant ready to proceed?
Yes, Your Honor.
Is the appellee ready to proceed?
Yes, Your Honor.
Appellant, you may proceed.
Thank you, Your Honor. Chief Justice, Your Honors, and may it please the court. My name is Emery Powers, and I, along with my co-counsel, Logan Kirkpatrick, represent appellant Justin Figg in this case. Your Honors, at this time, I'd like to request 4 minutes for rebuttal.
Noted.
Thank you, Your Honor. Today, we would ask that this court affirm in part and reverse in part the ruling below of the District Court of Portlandia. I will argue that Newton's motion for dismissal based on Portlandia's anti-SLAPP statute was properly denied, and my co-counsel will argue that the ruling granting summary judgment based on Section 230 immunity under the CDA should be reversed. Now, Your Honors, the district court below correctly denied Newton's motion for dismissal under Portlandia's anti-SLAPP statute for two key reasons. First, because Portlandia's state anti-SLAPP statute conflicts with the federal rules on civil procedure and should therefore be inapplicable in the federal courts. And second, because even if this court were to find that the statute is applicable in the federal courts, Newton's speech does not meet the minimum qualifications for anti-SLAPP protections. Erie established that substantive state law must be applied in the federal courts, but state procedural law should yield to the applicable federal rules. Now, a key consideration for the court is determining whether a federal rule on civil procedure answers the same question as the state law rule. And Your Honors, here, that's exactly what we have. Portlandia's anti-SLAPP statute answers the exact same questions as the federal rules that already govern pretrial dismissals. And what's further, Portlandia's state anti-SLAPP statute directly conflicts with those federal rules. Therefore, the state law should yield to the federal rules.
What is the conflict?
Yes, Your Honor. So the conflict is the standard, the burden placed on plaintiff to overcome the motion. Portlandia's state anti-SLAPP statute raises that burden significantly to require.
But that's not a conflict. That's just two different remedies.
Well, Your Honor, respectfully, it creates a conflict within the balanced federal procedures that already govern pretrial dismissals and the burdens that a plaintiff would have to prove to overcome those defenses within the federal courts. And further, Your Honor, the circuit split that exists currently on this issue, Portlandia's state anti-SLAPP statute reads much closer to anti-SLAPP statutes from the DC circuits, from the Fifth Circuit.
But there are, I mean, even if you just look within federal law, there are different federal laws that provide for different standards when it comes to these various motions. Federal Rule Civil Procedure 9 provides heightened pleading standards for fraud. You've got securities laws that provide for very different standards. Why isn't that just different remedies as opposed to a conflict that can't be reconciled?
Absolutely, Your Honor. The issue here is that the standard is significantly higher in a way that it conflicts and upends the balanced federal rules already in place. So where you're saying that there are already federal rules that create different standards, the federal rules in place for these pretrial dismissals, which would be Federal Rules 12, 12b6, 56, are already in place, and the state statute that Newton is advocating to have applied here in the federal courts directly conflicts with those standards.
I have a question. I have two
Yes, Your
questions.
Honor.
First of all, where is it in the Federal Rules of Civil Procedure that says that any of these dismissal before trial provisions are exclusive and can only be dictated by federal law?
It's not exclusively or explicitly within the language of the federal rules, Your Honor. However, courts have interpreted that the federal rules already sufficiently govern those questions of pretrial dismissal, and therefore allowing a state statute, and specifically a state statute that would bring a different standard in that conflicts with those rules, would make that state statute inapplicable within the federal circuits.
Well, the other side of my question is, why isn't this a substantive law that the federal courts are required to apply under Erie? After all, it contains attorney's fees provision, which neither Rule 12 or Rule 56 do in a similar fashion. And the states have enacted these rules to protect cherished First Amendment rights.
Sure, Your Honor. So we believe that the statute is procedural in nature. The language of the statute itself identifies itself as a motion to dismiss in relation to First Amendment rights that are themselves already constitutionally protected. So it doesn't create any new specific rights for defendants. And although most state anti-SLAPP statutes do provide for attorney's fees, that's not within the language of Portlandia statute on the record, Your Honor. It's not within the brief here. And further analysis on that point may raise that question. However, here it's not within the brief. But it brings us to a further question, Your Honor, about whether or not this anti-SLAPP statute would even apply to Newton if the court were to disagree and apply it within the federal circuits. And here, Your Honor, Portlandia state anti-SLAPP statute specifically requires that the statements made are in a public venue and in connection with an issue of public significance. Now, here we would contend the Newton Smack Board can hardly be considered a public venue under this statute. And although internet sites and other online forums are commonly recognized as public spaces for the purposes of anti-SLAPP and AMPEX, the court noted a few qualifications that would determine whether a website was considered public. And those were if it was free to anyone in the public, free of charge, so that they may read and freely contribute their own opinions and information. So here the SMAC platform, firstly, is targeted specifically at corporate employees as a space for them to vent. It creates a financial barrier to public engagement by requiring a purchase for the app. And the barriers of public engagement extend even farther into Newton's own private exclusionary SMAC boards. So she first chose to entitle the board Cloud Cheese Survivors, which inevitably targets the board solely at a small number of Cloud Cheese employees.
Who is effectively excluded from this venue? It seems to me that really nobody is, as long as you are willing to sign up for the service.
Sure, Your Honor. So that is true if you sign up for the service, if you can pay the fee to download the app. If you comment on Newton's board, which is a further consideration, she decided to make the board private in scope, so you could not freely read what was on the board unless you yourself contributed something under the heading she created. So it creates quite a few different barriers, both financial and then within the scope of what the discussion is.
When you say it's a barrier, do I understand it's $5.99?
Yes, that is true, Your Honor. And although we do concede that
Can any litigant avoid the SLAPP statutes simply by, or anti-SLAPP statutes, simply by imposing a low nominal fee?
well, Your Honor, here we do concede that it's a nominal fee, but we take it into consideration with all the other factors present here on the board. So not just the $5.99, but the private setting that she engaged, the titling of the board, the three very specific columns that she created, which was the stalkers, harassers, and rapists, that users had to comment within those columns in order to just access the board.
Counsel, why isn't Cloud Cheese, with its 10,000 investors holding $250 million worth of digital currency, a matter of public concern if in fact its executives and its founder are harassing, stalking, and raping women?
Yes, ma'am. I see my time is about to expire, Your Honor. If I could briefly address your question and conclude. Thank you,
may.
Your Honor. So here, it is true that Cloud Cheese has 10,000 investors, as you said. However, Your Honor, that's just one factor in considering whether a company may be one of public interest, and a few others are whether the company is publicly traded, whether the company publicly promotes itself, and all of those factors here weigh against the consideration of Cloud Cheese as a public company. That's not to say that they couldn't deal with sexual harassment claims within the company. It's just to say that it's not one that qualifies for anti-SLAPP protections. And for all those reasons, Your Honor, we would ask that you affirm the ruling of the court below. Thank you.
Thank you, Mr. Powers. Mr. Kirkpatrick?
Chief Justice Graves, Justice Wardlaw, Justice Ho, may it please the court. My name is Logan Kirkpatrick. I'll be continuing argument on behalf of the appellant addressing the 230 issue in the case at bar. Section 230 of the Communications Decency Act protects publishers from liability for third-party content, but it does so with a proviso. Subsection F3 of the Communications Decency Act, Section 230, says that any time that a publisher or someone treated like a publisher engages in the creation or development of the actionable content at issue, either in whole or in part, immunity under the title does not apply. We ask the court to rule that this exemption, finding that immunity does not apply, is what occurred today with Cara Newton for two reasons. First, Cara Newton fails the material contribution test laid out in the Ninth Circuit and endorsed by 6 other circuits. And secondly, Cara Newton's speech constitutes an independent act of defamation that she engaged in by commenting directly below the anonymous post at issue. First, we turn this court's attention to the material contribution test. In Fair Housing Council versus roommates.com, the Ninth Circuit laid out a distinction that is important to be drawn between publishers that passively display content on their websites and publishers that materially contribute to the actionable content themselves. And this material contribution test has been endorsed, among others, by the Fifth Circuit, Second Circuit, First Circuit, and Fourth Circuits. Essentially, the question under 230 analysis in circuits that we ask this court to join is whether the content was materially contributed by the actual information content provider, who was the same as the website provider, in this case, the defendant.
You
The
acknowledge
app-
the roommates case is a pretty narrow case where you're essentially, the platform's essentially compelling illegal speech, right? You have to express discriminatory preferences.
Absolutely, Your Honor. And we would ask this court to extend it in the way that other courts, such as the Eastern District of Pennsylvania did in Pace versus Baker White, as well as, Dossett versus Ho Chunk, among other courts, which have found that the logic applies to the case at bar anytime you have a material contribution. Here, the material contribution is evident because the actual anonymous post does not constitute grounds for defamation by itself. If you look to section 3 of the record, you can read the post in its entirety. It says, Justin Fig, 3 different women who worked for him. How do predators like this not get fired? This is ambiguous, and it certainly doesn't meet the actual standards for an actionable content of defamation. It's not clear.
How is that any different from Carafano and I think Dirty World and these other cases where you've got a questionnaire and the user is admittedly adding content by responding to the questionnaire, but that does not get rid of the 230 immunity?
Your Honor, it's distinct from either in a slightly different way. They're different fact patterns. In Carafano versus Metro Splash, there wasn't the actual creation of column headings that there was here. It's not evident what kind of predator the anonymous user was talking about
What's
here.
the difference between a questionnaire and column headings? I'm having trouble seeing that distinction.
Your Honor, the distinction is the actual answer to the questionnaire can exist in and of itself. The questionnaire, the mere act of asking a question does not need to be coupled with the answer to the question, and that was the holding in part in Carafano, in order to have defamatory meaning. This is actually also true of Jones versus Dirty World, where the actual content at issue spoke for itself. All 5 comments that were posted on the Dirty website spoke for themselves, and they did not need any additional commentary made by the website publisher to be defamatory. In fact, in both the trial and the retrial in Jones, there was not, the allegation was not raised.
So if the posting here had said Justin Fig is in fact a stalker, as opposed to just using the context, that would be different?
Yes, Your Honor. Absolutely. And that actually holds with the standard that was laid out in Pace versus Baker White, as well as in Fair Housing Council versus roommates.com, Batzel versus Smith and others, where the material contribution test asks whether you have independently sufficient defamatory meaning. And here it wasn't. The mere statement, Justin Fig, how do predators like this not get fired, doesn't indicate what form of predator he was being alleged to be, a financial, a physical, a sexual, nor does it actually allege who he was being a predator towards. It states 3 women, but as far as the comment on it by itself indicates, those 3 women could be witnesses or victims. It doesn't actually indicate really anything without the actual contributions made by the defendant herself. Once you add those contributions, once you see that the column heading was that of stalker, and once you see that the actual introduction was, the worst sexual abusers are, you can take the comment in and of itself as a whole and find that it
doesn't just say 3 different women. It's 3 different women who worked for him. How do predators like this not get fired? Why does, even accepting your hypothetical distinction, which I'm not sure I do, the word predator is in the statement.
That's correct, Your Honor. And it does indicate that there is some form, it's certainly a negative statement. But in Blumenthal versus Druge, the DDC stated that the mere negativity of a comment doesn't constitute an actionable comment for the purposes of a defamation claim. And so it does
predator is non-defamatory, but stalker is?
Your Honor, predator is more broad as a holistic analysis. Predator is a more broad comment. A stalker of those 3 women would certainly be defamatory. Calling someone a predator, it's a reasonable question that probably should be submitted to a jury as to whether that constitutes defamation. And the court under Anderson versus Liberty, as cited in Abbas, should not at the summary judgment phase say that no reasonable jury could find one way or the other on the question of predator. And the second independent reason that here Section 230 immunity doesn't attach is that Newton commented with emojis underneath the anonymous comment. And this is a complicated question. The district court found that the comment of emojis constituted basically the same information content, or could be construed as the same information content as saying, I agree with Justin Fig, or I agree that Justin Fig meets these allegations. The comment is a negation symbol followed by a cap, which
Couldn't the comment just as easily have agreed with predators in general should be fired?
yes, Your Honor, it could, but
it's very equivocal to me. I mean, the fact that you have to go to Urban Dictionary to figure out what it meant has to tell you that it doesn't mean that same thing universally to everyone.
Your Honor, that is true. But we think that because it is ambiguous and could be construed in different meanings, we should look to best practices. Eric Goldman is a linguist who's addressed this issue and says we need to look at it holistically in the context of the entirety of the prior statement. We shouldn't pick and choose. Other courts that have addressed emojis, such as People versus Griffith and in Jahan, as well as Nunes Verdalis and others, have said that you need to look at an emoji in the context of the entirety of preceding text. And you can't only say that it agrees with one portion of it. However, there's a close question. And if the court rules the other way, we should, at a minimum, we would ask this court to follow the guidance of Galloway versus US, as cited in Batzel versus Smith, and submit the question to a jury through a special jury verdict form pursuant to Federal Rule of Evidence 49. We think that a jury would be better able to address this complex question. Thank you.
All right, thank you, counsel. You've reserved some time for rebuttal. Appellee.
Your Honors, and may it please the court, my name is Apartham Vidyarthi, and along with co-counsel Ms. Tiffany Kyung, we are representing Appellee Kara Newton. I will be talking about the anti-SLAPP statute, and Ms. Kyung will be talking about Section 230. Today, we ask this court to reverse the district court's ruling dismissing the anti-SLAPP statute. Because we want to protect speech and reporting and ensure accountability in the technology industry and with respect to sexual assault. We have three main lines of reasoning. First, the anti-SLAPP statute supplements Rule 56, and overriding the statute would violate Erie's twin goals of preventing forum selection and ensuring an equitable administration of justice. Second, the original post was made in the public interest since it had to do with multiple instances of sexual assault. Third, even the more private SMAC board was an electronic public forum that was open to the public and open to public debate. So we'll get started with the anti-SLAPP statute. Then Judge Kavanaugh in Abbas outlined a two-part test. If the federal rule answers the same question as state law and the federal rule is procedural rather than substantive, the federal rule applies. If either of these fail, then we look at the Erie test. We know that the federal rule is procedural because every court since Sibach v. Wilson has decided that Rule 56 amongst all federal rules are procedural. So we state that the federal rule does not answer the same question as state law. Instead, the anti-SLAPP statute supplements Federal Rule 56 for two reasons. Number one, in some cases, you could apply the anti-SLAPP.
So are you contending it's substantive or are you contending it's procedural? The SLAPP statute.
We contend that it is substantive, and that's the second part of our reasoning here. The first part, very quickly, is that in some cases you could apply the anti-SLAPP statute, and if that fails, you could apply Rule 56, and the court must reasonably interpret the anti-SLAPP statute to avoid conflict, as stated by Justice Stevens in Shady Grove. The second part is that the state's substantive rights, Portlandia's substantive rights, are implicated because the state in its constitution and in the statute is protecting speech rights that go above and beyond the First Amendment rights enshrined in the Constitution. So effectively, if this statute is—
The statute is about dismissal at an early stage to avoid the costs of litigation procedure. You don't get more procedural than that, don't you?
Your Honor, it's a procedural mechanism that is intended to protect a substantive right. And although we don't have a full context of the entire Portlandia statute, what we do know is that in California and Maine, for example, there are more procedural mechanisms that also tread into substantive rights. And in the case of Lockheed, Judge Graves, you have a question?
No, go ahead.
Okay. In the case of Lockheed, the California Constitution has substantively more protective rights for free speech than just the First Amendment. So the state's substantive rights are implicated. And by definition, if this anti-SLAPP statute has a procedural and substantive mechanism, then it can't be only procedural. and therefore it can't entirely intersect with Federal Rule 56. So for that reason, the anti-SLAPP statute has to apply. But we have to go on to the Erie analysis, and the twin aims of Erie are implicated here. First, the premise here is that the internet transcends geographic borders, and with people using VPNs and new network topology, the chances that a case with two people in the same state arises is very low for speech on the internet that has to do with anti-SLAPP. Generally speaking, most people are in two different states. So forum selection is going to be a big issue here. Anyone who's sued in state court could move to federal court because of diversity jurisdiction. And if this court incapacitates the SLAPP statute by applying 56, then SLAPP statutes everywhere will basically no longer apply to most people who are contesting speech rights on the internet. And that implicates our federalism, as Justice Harlan said in Hannah. The other part of Erie is that there will be an inequitable administration of justice, because for all the people who are in state, so if there are two parties that are in state and are not allowed to have diversity jurisdiction, those folks will have to deal with anti-SLAPP. But all the people who are part of diversity jurisdiction will not be able to do that. So this is going to create a real patchwork quilt of different rules, and it will be unfair to some and fair to others.
Well, Mr. Vidyarthi, you are singing to the choir to me in that analysis, but I would like you to move on to how is this on a public venue on a matter of significant public importance with this tiny little company and this very private chat. There's only 30 employees who could possibly be addressed here.
Your Honor, I'll start with public interest and then move to public venue. So an issue is one of public interest if it's related to things that the public cares about, especially where multiple instances of that issue have arisen. And we can look to Doucette v. Ho-Chunk here, where a Native American leader was accused of multiple instances of sexual abuse or sexual assault. Now, we would like to point you towards the original post here, which
is not a leader.
Your Honor, you're correct. And while he's not a leader, I think that's just one of the factors that are important in deeming whether this is a public interest issue. The original post that Kara Newton made had to do with toxic masculinity, sexual abuse, and cloud choose. So this very evidently relates to issues of the Me Too movement and scrutiny on the tech industry. We're seeing that with Robin Hood as of a few days ago. What was not defendant's post, what was not Kara Newton's post, was anything to do with Justin Fig. That was made by an anonymous commenter, not by Kara Newton. So the original post had to do with public interest. Issues of public interest also include the private conduct of public figures, regardless of the issue's significance. And we can look to Damon for this. The original post had to do with Vanderkamp, who's the CEO of a company that has more than 10,000 investors, which is clearly something that is of a nature of public figure. Ultimately, there's a policy implication here, which is that if this court has too narrow an interpretation of what public interest means, then it will effectively be impossible for small-scale reporters like Kara Newton to do reporting, because she will have to know about instances and details of sexual assault before inquiring about them on the internet, which is a circle that is always going to be infinite. Finally, electronic media that permit open debate in a manner.
Your point that Newton wasn't asking about Fig, Newton was asking about the CEO. Is that sort of your idea?
Yes, Newton was asking about.
The CEO is not the plaintiff. Is Fig just collateral damage? Is that sort of the idea here?
No, Your Honor. If the appellants wanted to bring a case against the person who slandered Justin Fig, then they should have brought it against Jane Doe. But they clearly couldn't find this anonymous commenter, and Kara Newton had nothing to do with actually making that comment.
But Newton wasn't innocent. If Newton had said nothing, that'd be one thing. But Newton is participating in the exchange by sending that emoji, essentially crediting the defamation.
Your Honor, that is correct that she did. She was involved in that exchange, and co-counsel will argue about the ambiguity of the emoji. But the original post, again, was in public interest, and the subsequent posts are something that co-counsel will argue about. If I may very quickly, the last part of this is the public venue. Electronic media that permit open debate in a manner that is accessible to the general public are considered public fora. So here, although the setting was a more private setting, the public was still invited to comment on the forum. Sure, there was some effort involved, but if we look to Damon, where a homeowners association meeting, a board meeting, was considered a public venue, presumably not everyone knew about that meeting. And because there was no Zoom in the 1990s, people had to get in their cars, potentially pay for parking, and eventually take some effort to get to that board meeting. Here, the effort is very nominal. The public just has to make a comment on that post in order for it for them to be able to talk. This isn't the same as, for example, your or my Facebook wall. My Facebook is set to private, so only my friends can comment on it. There's no chance for the public to go ahead and talk on that forum. So the public was not invited and they are foreclosed from it, which is not the case here. And finally, very quickly, the cost of the app, although we admit that there is a $6 cost to the SMAC app, newspapers also cost money, but some courts do consider them public forums. For example, Damon. Again, if someone had to pay for parking to get to a board meeting, then that would still be a cost, but it would be nominal. And if a board meeting is considered a public venue, then so too should this be. Your Honors, if there are no further questions, we understand the plight of the appellant, but the best way to combat anonymous, slanderous speech is not with censorship and harassment of reporters, it's with more speech, something that this country and states like Portlandia value immensely to the extent that they've passed statutes explicitly trying to protect that. Thank you.
Thank you, counsel. Ms., I'm not sure, Kuhn, am I close?
Yes, thank you, Your Honor.
All right.
Good evening, Your Honors, and may it please the court. My name is Tiffany Kyung, and I am appearing on behalf of Appellee Newton. Today, we urge the court to affirm the grant of Section 230 immunity. While my co-counsel correctly argued that the motion can also be dismissed on the grounds of the anti-SLAPP statute, we emphasize that Section 230 immunity alone is sufficient for dismissal. In this case, Kara Newton is not a content provider. In fact, all of the defamatory content comes from Jane Doe and Jane Doe alone. This, in concert with the fact that courts nearly universally broadly construe Section 230, means that immunity must be imposed in this case. First, we'd like to begin by addressing the appellant's arguments and point out that there is an inherent contradiction between their 2 points. Their first argument is that Jane Doe's comments could not possibly be understood or be defamatory without any reference to the original column headings. Their second argument, though, is that somehow Newton's emoji reactions by themselves are defamation. Now, there is a contradiction here, because clearly, even if we take their definition from urbandictionary.com and say that no cap means no lie, you need to say no lie in reference to some kind of comment in the first place. The emoji cannot be understood without first referencing Jane Doe's comment, and they simply can't have it both ways. To be clear, it is our position.
Why are they having it both ways? Isn't their point really just that your client is essentially a collaborator with this anonymous speaker?
No, Your Honor. Our client is not a collaborator with the speaker in this case because there is a great amount of ambiguity in the emoji reaction, which I'll get into in my other point. But further, the way that we construed appellant's argument was that it would be impossible to understand Jane Doe's statements without reference to the stalker heading. We think that is simply not the case and doesn't make sense with their other analysis on the emoji. Now, moving on to the emoji reactions, we have 2 points under this. First, we agree that emojis are inherently ambiguous and can have multiple meanings, but in this case, the meaning is especially attenuated. Not only do we have to understand these 2 emojis together, but we then have to understand a dictionary.com definition, which anyone can edit, and see that no cap means no lie, a slang term which most of us in the court have probably never heard before today.
So
But
I'll
we
admit, I have
further-
not heard of that term before, but is there a alternative definition? Or is this simply the only, sorry, please, is there ambiguity
Your
in this
Honor.
term?
There could be ambiguity in this term. Perhaps the hat could represent individuals who are predators or male predators, for instance, and she doesn't want them in the workplace. But
Is there
even
any
if you were to
evidence
take,
that there is that alternative usage out in the world?
yes, Your Honor, I believe that because reasonable minds could disagree on the meaning of this, that could be an alternative meaning. But we do want to
Well,
emphasize,
it's not a
even
reasonable
if we
disagreement just
take,
because you say so. There has to be somebody else who adopts that usage. Who,
Sure,
who,
Your
ha-
Honor,
who
and
uses the term no cap in a different way?
oh, to be clear, Your Honor, we are saying that the emoji of the cap and the X could mean something besides no cap. But let's say that no cap does mean no lie. Even in that case, the individual Newton is not necessarily affirming that Fig is a stalker. She could be saying something like, yes, predators should be held accountable. And she further didn't.
Counsel, your argument is just focused solely on the emoji. I think there's a lot that came before the emoji that could arguably be construed along the lines as the roommate's case from the Ninth Circuit, where she was a co-developer because she not only put up the categories, which you could only, the person responding could only respond to rapists, stalkers, or whatever the third one was. Harasser, all of which are defamatory. And then she also has this cloud cheese equals toxic masculinity hellhole. Am I right? Roll call, ladies. Where sexual abusers are. And that is to what people respond. And then you get poor Fig up there. And so I think you have to look at the picture as a whole.
We understand, Your Honor, and in fact, we'll talk about those column headings right now. We do believe that roommates is distinguishable because in this case, although they may be inflammatory terms in some cases, like rapist, stalker, harasser, an individual could post something non-defamatory under those headings. They could perhaps post something that was true. That would certainly be legal. They could even post something under rapist saying that there are no rapists at Cloud Cheese. We know from precedents such as Daniel that as long as a tool can be used for proper or improper manners, then that tool is necessarily neutral and Section 230 liability still applies. But further, in the roommate's case, when you're asking about sex or sexual orientation in the context of housing, that is always going to be an illegal question. But here, Newton was asking a legal question. Do sexual predators exist at Cloud Cheese? She is completely within her rights to ask that. And in fact, she wanted to get true information. And there are real serious policy implications here. Recognize that if the court were to rule otherwise, any innocent individual who asked a question online could be held liable for the subsequent responses, whether they happen 1 minute or 10 years down the line, and we do not think that is appropriate. At the end of the day, Newton was not asking for anything illegal. She was asking for legal, truthful information about predators. Just because the individuals did not post true information does not mean that it is Newton's fault because it was completely out of her control. And further, we state
You
that
acknowledge most platforms don't then affirm or agree with the content being provided. They normally just let you speak and then move on. This is
yes,
unique.
Your Honor, I believe you're referring in this case to whether or not the emojis affirm some of the information given by Jane Doe, but we do emphasize that this is a question of law because even if we construed all the facts in the light most favorable to appellant, and even if we said yes, Newton was affirming that Justin Fig is a stalker and that's what no cap means, affirmation does not rise to the level of content development under the precedent set in Jones. In fact, the affirmation there was far more egregious and far more direct. After an individual was accused of being promiscuous, the website poster affirmed it and said, she must be because she is a teacher and all teachers are promiscuous and her partner is a sex addict. Obviously, there was nowhere near this level of affirmance that happened in this case. And still, in that Jones case versus Dirty World, to be specific, the court held that Section 230 liability still applied. And if it applied there, it would certainly apply here as well. Now, additionally, in speaking about the specific prompt and when she asked the question about predators at Cloud Cheese, we emphasize that courts generally do not accept an encouragement standard for material contribution, going against the first point made by appellants. We can look at Jones again, or we could even look at Blumenthal, where AOL paid a blogger, promoted his work, and was even able to edit it. And when he made a defamatory statement against Senator Blumenthal, AOL was still not liable. And for good reason. An encouragement standard would swallow the entire point of Section 230. And I'll just close by quickly addressing Pace. Pace is not on point in this case because here there are three parties. There is Fig, there is Newton, and there is Jane Doe. Jane Doe could not be brought to court as she is still anonymous. But in Pace, there was actually only two parties, the website operator and the individual who was being defamed. It was a different case where basically they used the plaintiff's words against him, and that's why the narrative structure had some importance in creating the defamation there. But again, in this case, all of the defamation is coming from Jane Doe and Jane Doe alone. And for all of these reasons, we request that the court affirm Section 230 liability because that content came from Jane Doe, and ruling otherwise would have negative impacts on free speech. Thank you very much.
Thank you, counsel. Rebuttal.
May it please the court. Opposing counsel have raised several insightful arguments. The jury deserves to hear them. In the case at bar, the appellee has brought a premature action to try to close off litigation on which appellant's opposing counsel has already acknowledged reasonable minds disagree. When that's the case, a jury deserves to be the arbiter of these close and difficult facts, and premature discussion should not be cut off. There are two reasons for this. First, under the anti-SLAPP issue, the holding in Shady Grove as cited in Abbas, and more fundamentally, the holdings in Hanna and Zabak, preclude the applicability just as a matter of Supreme Court jurisprudence. The question of the twin aims of Erie, as the unanimous court in Hanna has already explicitly articulated, do not come into play when there is a direct conflict with pre-existing federal rules of civil procedure that are valid. As co-counsel acknowledged, the validity of Section 12b6 and 56 have already been established. They're not at issue. And the question just boils down to whether there's a direct conflict, and there is. As my co-counsel argued under his first presentation, there's a conflict because the anti-SLAPP law of Portlandia imposes an elevated, substantial pre-trial likelihood of success requirement that is nowhere found within the civil rules that the federal government has promulgated. And it does so in a way that distinguishes itself from other federal circuits. The Ninth Circuit in Makeoff versus Trump University addressed the actual applicability of the anti-SLAPP law of California, as well as the one in Oregon, finding that there is no substantial probability requirement. It's essentially, there was a tiered approach adopted in that case where the allegations of factual insufficiency are used under the 56 standard, Rule 56 standard, and legal insufficiency is addressed under the 12b6 standard. That's the way the Ninth Circuit deals with California and Oregon's anti-SLAPP laws, synonymously with that of the federal rules. And so there is no direct conflict in the Ninth Circuit. There's also no direct conflict in the First or Second Circuit because those anti-SLAPP laws operate very differently, giving categorical immunity for certain types of actions as opposed to actual procedural elevated pleading standards. The second case, the second reason that this deserves to be heard by a jury is on addressing the Section 230 issue. As Justice Ho asked as opposing counsel during their presentation, we are not alleging a contradictory position where we're saying that, you know, on the emoji comment, we have an independent act of defamation, and on the anonymous posting, it was a dependent act. We're saying this is an act of co-authorship. This is what other courts, specifically Blumenthal versus Druge in the California court system, has said, that you can have an act of co-authorship in a defamation action such as this. The introduction and the column headings were key to the defamatory meaning of the post. Without them, the anonymous post would not exist or would not make sense. Similarly, the comment, no cap, articulating an agreement with the fundamental allegations within the actual commentary made by the Jane Doe party constitutes an act of defamation. It's one act of co-authorship. And again, let's just look at the actual standard of 47 USC 230 specifically states that even if an information content provider only supplies or develops part of the information, it's not even the entirety of the information, immunity does not attach under that law. We ask this court to uphold on the first issue, reverse on the second, and have this spirited debate continue into the courtroom and continue to be heard by a jury of Cara Newton and Justin Figs Pierce. Thank you.
All right, thank you, counsel. The court will take this matter under advisement. We are adjourned.
The judges will now retire to a separate room for their deliberations. Counsel and spectators should remain here.
While our judges are moved to their breakout room to deliberate, we want to give some thank yous, but I think we should start by giving our competitors a huge round of applause. I can hear it. I can hear people applauding and banging their pots on their balconies here in DC. You really did a fantastic job. We're also impressed, proud of you. And I personally am taking your names down so that I can hire you next time I have an appeal where I need legal representation, maybe a few years out after you've taken the bar. And I also want to do a few thank yous quickly. First of all, to the volunteer judges and timekeepers who have made this possible. We're really, blessed to have 3 esteemed circuit court judges with us this evening, but we've also had a lot of people, media lawyers, professors, and others who have served as judges for the quarterfinal rounds and semifinal rounds, and we had more students and therefore more judges and timekeepers this year than we've ever had before. So thank you very much for coming out. This wouldn't have been possible without you. We'd like to thank the American Bar Association, which hosts the Forum on Communications Law and the Moot Court competition, and also the good folks at Vision Creative, including David, for all of their technical support during the competition and conference. We want to thank definitely Lynn Carrillo, who's the chair of the Forum on Communications Law. It's really been inspiring to see her vision, leadership, and commitment to diversity, which have made this year's Moot Court competition unlike any other, despite the huge challenges brought on by the pandemic. And I also want to thank the other members of the governing committee who have helped put this competition on, made all of this possible. Professor Frank De Lamonte, who is sort of the heart and soul of our team and is also the author of the great hypothetical on which this year's competition was based. We've heard from everybody that it was a really fun, interesting hypothetical, lots of issues, and generated lots of good arguments. So thanks, Frank. Esther Clovis, who's an associate at Holland and Knight. Summer Ingram Dean, who's an attorney with the Student Press Law Center. Maggie Burson, who is an attorney at Jackson Walker. And Linda Riedemann Norbert at Thomas and Cicero. And myself, Alamid Sumar at the New York Times Company. And last, but certainly not least, we want to thank all of our sponsors who have generously supported the conference and the Moot Court competition. Without your contributions and commitment to diversity, all of this simply wouldn't be possible. So thank you so, so much. We're going to let the judges finish deliberating and we'll break for a few minutes, but we will be back with their comments and the announcement of the awards. So bear with us. Thanks very much.
I like your sneakers. I like your boombox. I like your backpack. I like your body pack. But most of all, I like your sneakers. I like your boombox. I like your backpack. I like your body pack. 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 I like your sneakers. I like your sneakers. I like your sneakers. I like your boombox. I like your body pack. I like your sneakers. I like your boombox. I like your headband. I like your body pack. But most of all, I like your sneakers. I like your I like your body pack. I like your But most of all, I like your sneakers. I like your boombox. I like your headband. I like your body pack. But most of all, I like your sneakers. I like your boombox. I like your headband. I like your body pack. 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 Body pack.
Welcome back, everybody. Thanks for staying with us. We're going to turn it over to our judges now, who are going to provide feedback to our competitors. That's Judge Graves, Judge Ho, and Judge Wardlaw. Take it away.
All right, it was a pleasure hearing the arguments. We are going to give some brief critique just to build suspense before we announce the winner. And we're going to begin with Judge Ho, with whom I sit on the United States Court of Appeals for the Fifth Circuit. And interestingly enough, we heard oral argument this morning in a couple of cases. Judge Ho.
Thank you. First of all, congratulations to all the participants. All four of you did a truly fine job today. Before I say more on that, I actually want to compliment the organizers, because I don't know who wrote the problem. Obviously, it's a fictional case, but honestly, not just an intellectually interesting case with genuinely difficult issues on both fronts, important things for all participants to wrestle with. Truly, when I was in private practice, I would often ask my colleagues, towards the end of a mooting process, if you could switch sides, would we do so? Just because I like to ask that question, because it generates a potential interesting further discussion and allows us to probe the case more deeply. This is a hard one. I don't know if I were on one side, whether I would want to switch to the other side, which I think does reflect that you all chose a good problem that gives everybody a nice challenge. So compliments to the organizers, because I know it can be hard to put these together. Judge Graves mentioned that he and I are actually sitting this week and had oral arguments this morning in two matters. I'm glad he mentioned that, because without in any way disrespecting the counsel this morning, and certainly without previewing what those decisions will be in those cases, I thought each and every one of you could have easily stepped in the shoes of the counsel today, people who are obviously much more experienced, further out of law school, and all that. You all each were performing at that level at a minimum. And that's very, very impressive. Most importantly, of course, these are hard issues, and we could certainly debate the substance, and that would be a wonderful thing to do over dinner sometime. But one of the most important things is just to maintain poise when you're being battered with challenging, hopefully polite, but certainly challenging questions. You all kept your poise. Nobody got flustered in any way, but not only did you keep your cool, but you got back to your client's position and were able to press your case. And so that was very, very impressive. Ms. Kyung, I want to mention in particular, I hope I pronounced your name correctly, I liked your use of cases. You would respond to the questions by talking very specifically about the case law that was available to you, and distinguishing the cases that you wanted to distinguish, not just by just asserting that they were different, but by really explaining the factual details of those cases and why they did not line up in the way that opposing counsel would have liked. So I wanted to compliment you in particular for your use of cases. Mr. Kirkpatrick, in a way, your co-counsel should all be jealous of you, because you got to do what I think is the funnest part, which is the cleanup. Because at that point, the battle is joined, and all you have to do, I remember, being a practitioner, you sort of sit there taking notes while you're listening to everybody, and you're trying to compete over which point you want to most make. And you had a nice sort of litany of points that really made your cleanup a powerful presentation. And of course, your colleagues didn't get to have that chance to do that. But compliments to you for taking what I think is the most fun part of oral argument and using it to your maximum advantage.
Judge Wardlaw. Judge. You're muted, Judge.
Thank you. I just want to thank everyone for including me in this moot court. It was the problem, I agree with Judge Ho, was quite complex. In fact, it's not often that you find two such complementary issues within the same problem, and you had to be careful in terms of the notions of what was public and what was not public across ways from the two issues. And I thought everybody really held the line on not slipping into a concession on one part of the problem that would hurt you on the second part of the problem. I agree also that, yeah, I mean, all of you performed so well and were very, very impressive, and great mastery of the law and the facts, and well beyond what I often see in my calendars. Performance from the lawyers. You guys really did a first-rate job, and so thank you for that. For particular points, I thought Mr. Powers did a really good job in responding to Judge Ho's searing questions about where's the conflict and how do these things actually work together. I thought that was really well done. And Mr. Vidyarthi, I thought your comments about the twin aims of Erie, I thought that was so important to be talking about, because after all, that's where this law comes from, this whole difference between substantive and procedural. And to circle back to that, I thought was really well done. Mr. Kirkpatrick, I too thought your rebuttal was good, and you picked up on some stuff out of the Makoff case that, since I wrote it, I picked up on too, that you, I thought, he got that. So I thought that was really good. And Ms. Kuhn, I thought you had a really good pivot to some of Judge Ho's questions. I have to say, I'm not sure I'd want to appear in front of Judge Ho. He asked really tough questions, and you did a great job. So anyway, all of you did a fantastic job, and it's no wonder you were the highest point earners and got to argue today. So congratulations to all of you.
All right. I don't have very much to add. I think my colleagues have covered almost everything. I, like Judge Ho, want to commend the organizers, the people who put all of this together, the writer or writers of the problem, and the ones who made sure everybody showed up in the right place at the right time. It takes a lot of work to pull something like this together, and I can't even imagine doing it virtually, but it has happened. And so I just want to commend the organizers. It's always very well run. And again, this year, you just outdid yourselves. To the competitors, both teams were very, very good. You've gotten very good, I think, critique from both Judges Ho and Wardlaw about substance and content. A couple of things on style, and style matters, delivery, demeanor, those things matter. And all of you, I think, had a very good demeanor. Everybody seemed pretty relaxed. If I had to offer a negative comment, there was someone with hands in pockets often, and hands in the pockets looks almost too relaxed. Now, sometimes people have a problem with what the heck am I going to do with my hands while I'm talking, because I talk so much with my hands. And so if you have a podium, you kind of want to put them on the podium, and then maybe they work their way into the conversation. But where your hands are is important. You don't want them to be a distraction, but having them in your pockets can look like, it can look a little bit too informal. So you want to avoid that. And very specifically, and I made notes, and almost to a person, everybody did a really good job of fielding questions and then getting right back to the argument, which is what you want to be able to do in an oral argument. The other thing you all were good at is actually listening to the questions. Oftentimes, there will be an argument and the lawyer treats it like it's a race. And so before the judge has even completed the question, the lawyer is beginning a response. Well, it's not a race. and you shouldn't assume you know what the question is going to be. There's nothing wrong with taking the time to listen to it. And so you all did a very good job of listening to the question, and then you were responsive to the question. And it sounds like that's something I shouldn't have to say, but there are lots of people who just don't listen and then respond to what the question was. You all did a really good job of that. Miss Kyung, you got to make me say it correctly. So I want you to unmute and say it one more time.
It is Kyung, Your Honor.
Ms. Kyung.
Yes, thank you.
Ms. Kyung, you did both Judges Wardlaw and Ho were throwing really hard questions at everybody. You did a very good job of pivoting back, a good job of being forceful but appropriately deferential. I mean, you want to be forceful, you want to be confident in your argument, but you don't want to be argumentative with the judge, and you want to show deference to the bench. And I think that you did a very good job of that, and you had to, because you had a lot hurled at you, as did Mr. Powers and the rest of you. And so all of you did a good job of getting back to what you want to talk about. To Mr. Kirkpatrick, the rebuttal, the opening line of the rebuttal, when you began with, you said they've made some very insightful arguments. And my thought was, so where's this compliment gonna go? Because you're praising the other side, but then you said, the jury deserves to hear. And that was a great way to get us off. Well, so we're gonna be leaving here on a 12-day-6, so we're gonna be leaving here on a rule on a Rule 56 motion for summary judgment. Neither one of those should happen, because the jury should hear these arguments. And I thought that was a great way to begin a rebuttal, because it got my attention because you were offering praise. But then you quickly turned it right around and said, but that's why the jury needs to hear the arguments. And then you made good points, and you listened to the argument of the other side, and you were responsive to what that argument was, which is what rebuttal is supposed to be. I think that's all I have. My other notes are so cold I can't read them anymore because my handwriting is so bad. After about 2 minutes, I can no longer read it. So that's all I find legible. But you all did a great job. I will announce the winners when I am told to do that. I don't know if somebody else is going to be saying anything.
Judge Graves, I'm gonna steal that thunder from you.
You're gonna do it?
I am. Oh, I mean,
no, go ahead.
Only because we scripted it out already. But in all seriousness, thank you to the judges so much for taking the time out of your busy schedules to come here on a Tuesday evening to volunteer and to give so much insightful feedback, but also to keep the bench so hot. You know, I'm in New Jersey right now where it's freezing cold because of about 20 inches of snow outside. So you guys are keeping us warm with a very hot bench this evening, and we are very thankful. And also, as Alameen mentioned before, Frank Lamonte is a professor and who is really the heart and soul, like Alameen put it before, of our committee, and he wrote the problem, and he's just brilliant, and that was really seen through all the materials that you guys received and used to prepare for this evening. So thank you again to Frank. And with that, I also just want to shout out our competitors, because as the judges said, we all saw they did an amazing job this evening, and they've spent the past several months preparing for today, and indeed their hard work has paid off. And so thank you all for doing so much work to get to this point today, because without competitors, we don't have a competition. So thank you so much for that. And finally, the moment you guys have all been waiting for, we're pleased to announce the prizes. And so for the award of Best Oralist with a cash prize of $1,500, we are pleased to announce that that is being awarded to Logan Kirkpatrick of the University of Chicago. The winning team, and they will be receiving $750 each, is the Applees, Tiffany Kyung and Apratim Vidyarthi. and they are from the University of Pennsylvania Law School. And the best brief, which comes with an award of $1,000 to each individual, also goes to Apratham Vidyarthi and Tiffany Kiang. And we would also like to take a moment to recognize Carolyn Forrest, who's the past chair of the Forum of Communications Law and the general counsel of Tubi, a division of Fox Entertainment. Carolyn has been a personal mentor for me and is really the reason I am involved in the forum. So I'm really pleased that we are presenting this today. But Carolyn's leadership and her mentorship has really left a mark on all of those who've been fortunate enough to know her. And this year's inaugural Carolyn Forrest Moot Court Recognition of Achievement, which comes with an award of $500 to each recipient, is given to Logan Kirkpatrick of the University of Chicago and Emery Powers of the University of Houston. And lastly, the 4 finalists here today will be offered the opportunity of summer employment opportunities with a top law firm, a media company, or a First Amendment nonprofit, thanks to the generous support of the ABA Forum sponsoring organizations. With that, we'd like to thank you all for joining us for this program. We hope you enjoyed it. Have a great night and stay safe.